Number 35, Griffin versus Sirva. Counsel?
Your Honor, I'd like to request 2 minutes to reserve for rebuttal.
Of course, you may.
My name is Stuart Lichten. May it please the court. I represent plaintiffs, appellants, Trathany Griffin and Michael Godwin. On February 8th, 2011, Mr. Griffin and Mr. Godwin were asked to sign a piece of paper which, quote, authorized Sirva, Inc. to investigate my background. 2 days later, their workplace received an email stating that Mr. Godwin and Mr. Griffin did not meet company standards, and they received letters at their homes advising them that they were not qualified to interact with Sirva's customers. The next day, they were fired. Mr. Griffin, that was a job he held for 2.5 years. He hasn't been able to obtain full-time employment since. On that record, the district court dismissed the case against Sirva and its subsidiary Allied entirely on the grounds that Sirva and Allied were not employers of
Counsel, who paid the salary for Mr. Griffin and Godwin, and who sets the terms of their work? Who gets to set their hours and when they show up and what they do?
Well, they're paid by Astro Moving and Storage Company. That's the name on their check. The terms and conditions of their work is a larger question than just the hours and the schedules. The hours and the schedules were set by Astro, but whether or not they could be there in the first place was set by Allied and Sirva. Whether or not they were qualified to interact with their customers was determined by Sirva and Allied, and was told to Astro, and that if Astro disregarded that advice, they were subject to fines, they were subject to losing 70 to 80% of their business.
If we were to agree with you that Allied was an employer under the definition of Section 296.15, how does that interplay with the aiding and abetting provision of 296.6? It seems to me that it would kind of render the aiding and abetting superfluous under these circumstances. Would you address that?
Under Section 296.15, it does not say employer. It says person, agency, bureau, corporation, or association.
Well, but it also refers you to the correction law, so you can't view that in isolation from what Article 23A of the correction law provides, correct?
That's correct, but the human rights law does not require you to be an employer in order to be liable under this statute.
Well, that's the question that we're here to address. I understand that, but my question is a little more narrow. If that were the case, if we were to interpret it that way, then what is the meaning of the aiding and abetting?
Well, the aiding and abetting, there might be some overlap between the two, but it covers more situations.
Such as?
Well, you can be any person at all under the aiding and abetting clause. You don't even have to be an employer or a person or any of the...
But I thought that's what you said, that the first sentence of 296.15 says any person, right?
Well, there's still five entities listed there. Under the aiding and abetting, it's any person, but besides that...
So you say that subdivision 15 is narrower than subdivision 6. Can you just give me some examples as to where one would apply and not the other?
Well, you can aid and abet, which the courts have said simply means that you engage in conduct that assists others in the performance of prohibited acts. You can, in the instance of the Now versus Gannett newspapers case, the defendant was a newspaper who had sexist ads and didn't employ anybody. There was no employment-specific relationship involved in that case at all. And so therefore, they couldn't go under 296.15 because it wasn't an employment situation. But in the aiding and abetting was just the printing of the ads, even though there's no specific person who was identified as being harmed by the ads. So that's an example of somewhere where they would be found liable for aiding and abetting, but not being found liable for committing an improper practice and unfair practice under the human rights law.
Following up on what you just said, counsel, the definition of who would be someone who could discriminate is pretty broad in terms of individuals, partnerships, associations, corporations, et cetera. But are we to look at the statute under its plain terms, or look at it in reference to a particular situation, like an employment situation that we have here, and who would be an employer for those particular, the circumstances that we have here?
Well, I think when the legislature wrote 296-15, they specifically stayed away from putting employer as a requirement. So even looking at the plain language, looking at the statute as a whole, looking at the intent of the statute, looking at Section 300, which says you have to liberally construe the statute to further its aims, under any of those rubrics, you have to...
But you haven't mentioned the correction law, and that's integrally related here, is it not?
Well-
And isn't that what the correction law refers to?
Well, it
Employers, public agencies, and private employers?
It refers to them in that section of the statute, but it doesn't say that the only people who can bring a cause of action are private employers or public agencies. I mean, this case is brought under the human rights law, Section 297, executive law, which specifically says that a victim of these types of practices can bring in a private cause of action. The correction law doesn't.
I take your position, though, is that Gannett, in the Now case, was not a person who denied employment. Is that right?
Correct.
Even if the result of the ads was that people weren't employed, women
Right.
weren't employed.
They weren't required to show that they denied employment because that was brought under the aiding and abetting statute.
But I'm not asking you what it was brought as. I'm asking you whether Gannett, in that circumstance, is an employer. In the context of 15, a person who denied employment.
They were not.
Okay, and why? That's what I think what we're wrestling with. How broadly are you expanding employer?
Well,
It doesn't reach somebody who takes an ad out, but it does reach Allied because
Allied had a significant level of control over the discrimination policies and practices of the direct employer. They determined who the direct employer could and couldn't hire. They told them, if you hire this person, you'll lose all our business and 80% of our business. You can be fined. You can have the permanent loss of business. That level of control, Astro is basically outsourcing its discrimination policies to Allied and Sirva. And under that situation, if they're doing that, then Allied and Sirva can be liable under the human rights law for carrying out those discrimination policies and practices.
Well, we've been given a number of different tests that have been offered, joint employer, the joint employer doctrine, the single employer doctrine. I think there's some amicus briefs in the state have also indicated an interference test to define the scope of employer. But would your concerns in your case be met by application of simple agency law?
I don't.
So, in other words, if Astro is simply acting as an agent for Allied Van has discriminatory policies, therefore, if Astro's discriminates, they discriminate. Allied discriminates.
That could be one way of looking at it.
What would the effect of the jury verdict in this case be? Forgetting about the general application law, but it would affect the jury verdict in this case.
The jury verdict was not presented with an agency type of instruction. The jury, in fact, one of their notes seemed to suggest that they believed that Astro was an affiliate of Allied. And in fact, Astro's CEO testified that they were a subsidiary of Allied, which isn't technically true. They're two separate companies.
Well, the reason I'm a little bit reluctant to move into these other tests outside of New York law, tell me why we should look at another test, or what test you would advocate.
Well, first, our primary position is that you don't have to look to the other tests because there's no requirement that a defendant be an employer in order to be liable under the human rights law.
So, but let's say we disagree with you on number one.
Okay.
All right.
Then I think we have to look at other tests because if we use the traditional definition of employer, the aims of the statute are not going to be furthered. That's what the Second Circuit seemed to intimate in sending over question number 2. where they propose, and the plaintiffs would concur, that the test should be exercise a significant level of control over the discrimination policies and practices of the direct employer.
Should we look at cases under Title VII to answer that question?
Well, it depends. As a general rule, I would say no, because
Haven't we said that they're comparable and?
well, there are some cases under Title VII which I think would be instructive. The Spurt case, which says the test is if the entity significantly affects access of any individual to employment opportunities, or where an employer has delegated one of its core duties to a third party.
Well, haven't the federal courts kind of overruled that, or?
I wouldn't say overruled. I mean, it's been hemmed in, but it's still good law. The Second Circuit is still, it still cites it, and it has not overturned it.
Why isn't the aid, abet, incite, coerce, compel language sufficient for you here?
It is. I mean, it is sufficient, but
Why isn't that a simpler way out of this than wrestling with who's an employer and what the test ought to be?
well, because the employment part of the statute is the major part. That's, if you bring a case against the defendant, it's hard to just rely on the aiding and abetting, because you're overlooking a major part of the statute. I mean, I think they should, in order to further the liberal reading of the statute, which furthers the intent of the civil rights law, I think that you should not require that the defendants be an employer. I mean, in this particular case, maybe that the aiding and abetting might be enough, but in other cases, it might not be. I don't know if the Now case, which is still good law and really shows the way here, it reversed the Fourth Department's requirement that you needed knowledgeable and intentional discrimination. It would be sufficient here to say that at the very least, the plaintiffs have shown that Allied and Sirva were aiding and abetting, or inciting, or compelling, or coercing, for that matter, the remaining part of the aiding and abetting statute. But as a matter of law, it's also true that they showed that Section 296.15 was violated, and we would argue that that should be the law of this court.
Thank you, counsel. Counsel?
May it please the court, Philip Tisney for the state of New York. 296.15 is not limited to employers.
So
That provision-
let's get to that aiding and abetting. Why isn't that the proper way to look at the statute and these two provisions, that the aiding and abetting captures the kinds of actors that the state is concerned with?
Well,
Why isn't that good enough? Is it because of the primary liability question? What is it?
Certainly, the aiding and abetting provision captures this conduct here. Certainly, as the Second Circuit has framed the question, but I think it's the posture of which this case comes to this court. This court, we're going to resolve this case in the normal course. Of course, the easier way to do it would be on the aiding and abetting, but this comes on a certified question. The Second Circuit has asked this court to settle two questions of New York law that will help it resolve this case, and so this court is duty-bound to answer those questions to aid the Second Circuit in resolving.
We do have the discretion to reformulate those questions, no?
You certainly do, but the
So,
Second Circuit is going to have to answer both of them regardless, so.
Why is that the case? Or let me just posit this. Suppose what we conclude, I'm not saying we are going to, but suppose that what we conclude is that Section 6 expresses a broad interest of the state in the human rights policy that even people who aid, abet, incite, compel, or coerce, or attempt to do those things are liable under the statute. Why do we need to worry about the precise contour of employer if all that other conduct is reached by the statute, and that was the legislature's intent?
Well, I don't think every situation that is encompassed by direct liability is also encompassed by the aiding and abetting liability. For instance, the interference theory, which we've discussed, would apply in a situation where a company takes over a piece of the hiring process and injects its own discriminatory practices into the hiring purpose. The standard, the quintessential example is the staffing company that screens out applicants based on a discriminatory practice.
And that wouldn't
In that
be-
situation,
and that
they
wouldn't
would
be
be
aiding or
directly
abetting?
liable. I'm sorry.
And that wouldn't be aiding or abetting?
Well, they wouldn't have aided and abetted anybody else's discrimination because the only discrimination there is their own principal discrimination. The company that they're screening applicants for could be agnostic about whether they take people with criminal convictions or not. It's the company that is screening out applicants that is introducing discrimination into the process. So there isn't an on-to relationship between these two provisions. There's certainly significant overlap, but it's not
You mean when you
perfect.
don't have like Allied, who's got this rule or policy that they impose?
I'm sorry?
Your example is when you don't have Allied who's imposing the rule, but it's just this other actor who's not going to be the employer who imposes this rule.
Well, I mean, it would
Is that what
apply.
you mean? They wouldn't fit the aiding and abetting or employer, and they're lost?
I think given the specific facts of this case, the overlap is fairly complete. That is to say that because of their involvement because of Allied's involvement with the employment decisions of Astro, that while it will be liable directly, it will also be liable as an aider and abetter. But I don't think that in every case, those two things
But
overlap.
Going back
So
to that
getting back to
question,
the-
I'm
excuse
sorry.
me. Counsel, getting back to the initial question as to whether or not 15 applies to employers, talk about the interplay between the corrections law and 15.
Sure. Well, 296.15 defines the scope of entities to which it applies, the scope of entities that are prohibited from engaging in discrimination, prohibits any person, bureau, agency, association, or corporation from engaging in illegal conviction discrimination. The substantive provision of the Corrections Law 752, doesn't even talk about who is prohibited from engaging in illegal discrimination. It uses a dramatic passive voice formulation of it by saying that no application for employment or any employment shall be denied or adversely affected. There are other provisions, certainly in the corrections law, which discuss or mention employers,
Does
but
it
they don't
reference
limit.
private employers and public agencies?
The closest situation where the correction law references private employers is in 751, which is, that is not a provision that defines the class of entities that are prohibited from engaging in illegal discrimination.
Well, is
That
there any
defines-
significance to the fact that under Section 753, which sets forth the factors to be considered concerning a previous criminal conviction, says in making a determination pursuant to 752, the public agency or private employer shall consider the following facts?
Well, I think what that section is saying is that when the entity that is in the position to make the hiring or firing decision makes that decision, then it has to take into consideration these factors.
But there it clearly refers to employer, and you're saying, now you're asking that we find that staffing agencies, hiring companies, things like that, fit within that bill, but they're not a private employer or a public agency. So how does that relate to what you're suggesting?
A company that doesn't make the actual hiring and firing decision and therefore doesn't have to take into consideration the factors that are set out in 753, nevertheless could be said to deny employment where its involvement in the employment process or the hiring process of a company that is hiring workers, that is making the actual decision.
But I thought you
prevents-
said that they're making the actual decision because they're screening them out. It never gets to the direct employer.
Well, no, they don't. So let me be clear. When I refer to a direct employer, I'm referring to the entity that actually makes the decision whether to hire and
So
fire.
that could be a staffing agency.
Well, no, because the staffing agency isn't hiring somebody or firing somebody. They are controlling which applicants go through to the ultimate company who's going to make that decision, but they aren't actually making the decision themselves. But that doesn't mean that they can't be said to have denied employment as to every person that they screen out. They're not even letting them get their foot in the door, and they're doing so for discriminatory reasons. It's the same effect.
The question
as if
is
they-
whether they're, well, I'll take that back. Go ahead.
The fact is that 296.15 simply doesn't refer to employers. It refers to any person who denies employment. And there are circumstances where a company that doesn't make the actual hiring and firing decision can be said to deny employment based on its involvement in the actual hiring and firing decision. We've talked about the interference theory, the staffing agency. This could also happen where a company that isn't making the actual decision effectively controls the hiring process of the company that is making the decision, for instance, by imposing discriminatory hiring criteria. In that situation, the company that sets the policy would be said to have denied employment because it's the policy that results in the denied employment just as much as it is the person who actually implements the policy.
It seems like you have two types of tests. One is one is a series of control tests, and then there's the interference test. Is there any limit to the interference test? How far does this extend? I mean, in theory, you know, a government agency that didn't make a regulation could be interfering. I'm wondering what the parameters are of this
Sure.
interference test.
And I think the D.C. Circuit's decisions in Sibley
Right, it's a 73 case. I looked.
and Red as well that follows it sort of describe the limits that you're asking about, which is to say that the company that is doing the interfering has to be within the employment decision-making process. If it stands outside of that process, if it acts like a customer and not somebody who is together with the prospective employer providing services to the world, then there wouldn't be a sufficient connection to the employment decision to allow the interference theory to come into play.
I see.
I'd like to speak very briefly about the aiding and abetting. Like we said, it clearly, as the circuit has framed the question, certainly a company that requires another company to engage in illegal discrimination can be said to have compelled or coerced that company to engage in discrimination. The record also suggests here another basis for accomplice liability. That's where a company gives substantial assistance to another company in engaging in discrimination. We think both of those are potentially applicable in this case.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors, and thank you for the scheduling accommodation today. The human rights law is not a suicide pact. By that I mean it is not a law that mandates the hiring of persons with criminal histories under all circumstances, no matter what the potential cost. It does something quite different. The legislature struck a delicate balance when it enacted these laws in 1976. The legislature sought to, of course, encourage the employment of people with criminal histories, but it gave precedence and priority to public safety and the safeguarding of property. The safeguarding of property covers a lot of territory. Obviously, in the context that we're dealing with in this case, it applies to the safety of our customers and their property. But I would also ask you to consider the fact that property includes the property rights of the service providers in question, the integrity, the financial integrity of their businesses and their business reputations. Those are all property rights we would respectfully submit that are...
Counsel, if in 296.15, the legislature only meant employer, why is that not in that first sentence? Why does it say person, agency, bureau, why does it say that instead of employer? Since it uses employer later in the same section.
Yes. I would, and I can only guess, that when the legislature listed the 5 or 6 categories of potentially responsible parties in sentence 1, they were mindful of the fact that they used those exact same words in the definition of employer in section 296, and also the same words are contained in the labor law, section 190, where that statute defines employer. The legislature, I believe, and I don't know the answer why the word is not in the first sentence, but it caught my attention that the very next sentence, the second sentence, which uses the word employer twice, begins with the word further. I think that's a clue. I think that's a clue that the legislature meant the first and second sentences to run one from the other seamlessly. and that when the legislature talks about employer in the second sentence of 15, it's talking about the same entities that it mentions in the first sentence. There's also the fact, as you mentioned earlier, that even the first sentence references Article 23A. And this gets us into what is the gravamen of a violation of a corrections law. And it hasn't been talked about yet. But as we see it, the essence of a violation of the HRL is found in 23A. And it's dual. It's the failure to consider the 8 factors coupled with an unreasonable termination of employment or denial of employment. That's really the essence of a violation of the HRL. So it makes no sense, and this court has commented in Albano, you don't construe a statute by taking it out of context, and that's what the appellants are advocating. In context, it's very clear to us that the first sentence of 296.15 must refer to private employers and public employers. In our case, a private direct employer. And here it's Astro, it's not Allied. So looking at all those factors, all those clues that the legislature gave
So
us.
is then, under your theory, the only way Allied could be liable if there has been a discriminatory act? I know you dispute that, but let's just assume for one moment,
Yes.
is under the aiding and abetting provision?
I think it's a fair statement, because the aiding and abetting provision in 6 is broad enough to cover anyone who might substantially assist or actually participate in a discriminatory act. And I think those two phrases are synonymous. They imply that the principal actor has knowledge that he or she is promoting an unlawful act. We clearly argue that doesn't apply here, certainly not in light of what happened below. But as we see in the Now case, it can apply to parties who are not direct employers, who are not defined as such in the other parts of the statute. So we would contend that the aiding and abetting part of the statute is the catch-all that the legislature intended it to be. And we would also submit that the rest of the statute, insofar as it applies to direct employers, is fully enforceable as the legislature meant it to be by holding direct employers accountable. They are the only parties who are really capable, well, they're the only parties who are required to consider the 8 factors as a practical matter. They're the only parties who are able to do so. A party who merely does business with an employer.
What is the test or definition for employer, assuming that we agree with you that it only applies to employers? What is the test or definition that you are asserting we should find applicable?
We only ask that the court apply its own decision in Carter, which is to acknowledge and reiterate, reaffirm the dictionary definition of employer, which is one that everyone understands what it means. So it's not only valuable to lawyers, but the public understands what an employer is and what an employer is not. So with that as the starting point, I think that if you look at the Petrovich test, to the extent that there might be a third party that is not nominally the employer, but who in fact so controls the nominal employer to the point where that employer has no free will, which doesn't exist in an arm's length contractual situation typically. But I think that Petrovich provides a guide for looking at who else might be deemed an employer under the rest of the statute, excluding aiding and abetting.
Counsel, could you just respond to your adversary's position that just aiding and abetting isn't enough to further the aims of the statute to prevent discrimination in the circumstances that we're looking at?
Well, I'm challenged to understand what consequences there could be in any particular situation that would not be remediable under either aiding and abetting or holding the direct employer accountable. Someone has hired the aggrieved party at some point, and if that someone has violated the statute, that employer may be liable. Now, I don't know how it's possible to have more coverage than to add to that standard of liability what is provided.
In this case, and correct me if I'm wrong, but I think the jury found that Astro was not liable for discrimination, even though it essentially terminated these two employees.
Yes.
Based on the information that it received from Allied's vetting company. So if Astro was not liable, then you're saying that, I guess you're saying that Allied would be liable only on an aiding and abetting theory.
Well, that's our view. And factually, if I can be very specific,
How would they be held liable if Astro was not held liable for discrimination?
if we have, as we do in this case, res judicata on the finding of non-discrimination and non-liability, where the only possibility is that if there was any theoretical possibility that Allied could be liable to these plaintiffs, and their own employer who terminated them was found not liable, then there's no practical mechanism that we can think of, that we see in the record, that would make Allied liable just because of the existence of its rules, which...
But see, this is where I'm having a problem with your argument, because it isn't the statute and the legislative intent to get to exactly the entity like Allied, the one that sets the policy, the one that sets that rule that then everyone else has to fall in line. Isn't that the problem, that Astro may not very much believe in this view that Allied has, but it's about the bottom line, it's about money, and I want to keep this contract, or I want to keep this arrangement with Allied, I want to keep this business, and so they fall in step. And so isn't this statute about getting to really the source of the discrimination, which is the decision maker, which is in this case Allied?
No,
and that's why it doesn't say employer in the first sentence.
No, we don't see we don't see anything in the first sentence that implies that it extends to the world, which is basically plaintiff's argument.
No, it doesn't say that. It says that to deny any license or employment, right? That's your focus. It's not to the world. It has to be some entity, an individual or an entity, that has some role in this. And all I'm suggesting is, isn't the point of this to get to the source of the inherent discrimination, which is that view that someone who has a criminal record should not be employed in a particular job. And in this case, that's Allied that's making that decision. That's who you want to get to, because they're the ones who will influence the market and the opportunities. It may very well be, I understand your position, it may very well be that if what the correction law anticipates, which is those balancing of factors and seeing if otherwise this is the kind of individual who should not be employed in a particular job, once doing that, that termination or not allowing them to work in certain positions is totally appropriate and not a violation of the statute, right? But isn't this focusing on the people who make, or the entity that sets the game rules?
We don't see that in the statute, Your Honor, to be direct. We don't see any indication in the way the statute is framed and worded that the legislature meant to reach beyond direct employers, and we're excluding aiders and abettors, to reach beyond direct employers to other third-party, non-employer decision-makers who might influence them in a decision.
Well, when you say to excluding the aiding and abetting, that doesn't just include aiding and abetting. There's also incite, coerce, compel, and it says attempt. So
yes.
Why does the judgment you're claiming has res judicata effect prevent a lawsuit under Section 6 against Allied on the theory that they attempted to incite or coerce or compel, and that's the effect of their policy, and the legislature meant to get that, regardless of the result?
Well, res judicata would cut that off, I believe, Judge, because if the attempt requires that either the act was near at hand or capable of being achieved, at least in the mind of the perpetrator, that never happened. There's no evidence, and there never will be, that Allied had any reason to believe that what it was asking its agent Astro to do in complying with these rules, that Allied had reason to believe it was unlawful. Allied, on the
But
contrary,
neither did Gannett.
required.
Neither did Gannett.
Well, Gannett knew that the HRL in Section 291 forbade sex discrimination. And it certainly should have known, at least in hindsight, that its ads were promoting that. But what we have here is a policy that even if Astro had devised it and implemented it itself, would be lawful. The policy would be lawful because the result is lawful. The result of excluding the worst of the worst, the apex felons, from going into people's homes and providing services and heightening the risk to the employer sending them into that home is exactly the kind of result that the statute allows and contemplates.
That might be a basis not to be held liable. It's not a basis to seek exclusion from the coverage of 296.15 as an employer.
No, our contention with respect to 296.15 is simply that, read in context, both with respect to the second sentence that follows in Article 23A that is incorporated by it, it's clear to us that first sentence only was only meant to apply to employers. But getting back to the essence of Allied's position and what it did, the policy that Allied promotes is designed to be applied in all 50 states, and I say that more as context than a defense. But looking at this particular policy, not only did it require Astro to comply with New York law as the New York employer, but if Astro or any other agent believes a particular policy might violate its local state law, the agent has the right under the contract to appeal from that, to seek a rescission or modification. So I think that's very inconsistent with any suggestion that there was an attempt to violate a statute. There's simply no objective evidence of that in this case.
Thank you, counsel.
Thank you.
I'd just like to take a minute to talk about the interplay between Executive Law Section 296.15 and Correction Law Section 753. First of all, the Executive Law does not adopt the Correction Law's definition of who is liable. It does refer to Article 23 of the Correction Law, but it just says that in order to be found liable for violating Section 296.15, you have to discriminate against someone based upon his having been convicted of one or more crimes when it's in violation of the provisions of Article 23, which means when it doesn't comport that the two defenses that are provided in the correction law are not appropriate. It doesn't say that that you have to be an employer, that you have to be a public employer, or you have to be a private employer or a public agency, because Executive Law 296 just refers to the correction law for that specific limited purpose, doesn't incorporate it in whole. Second of all, just because public agencies and private employers are liable under the correction law doesn't mean they're not liable under the executive law. The executive law can add people who are liable, or say a different group of people are liable than the correction law. The correction law doesn't exempt anybody from the...
If we adopt your interpretation, would that result in greater protection to persons with criminal backgrounds than those who are discriminated against on the basis of, for example, race or sex or age or any of the other number of things that are covered by the human rights law?
No, I wouldn't say it's more protection, it's just different protection. And I think the Second Circuit intimated why that is when it talked about how an out-of-state actor like Allied or Sirva, coming from a state where discrimination based on criminal history is not against the law, and then having their agent violate what is against the law in New York. That's why the provision.
But do you believe that somebody like Allied would be held liable if this situation were based on some other kind of discrimination?
Well, sure, if their certified labor program said you can't hire women in a specific job as driver, then they would be held liable
Well,
for
but
that.
they're not a certified labor program.
That's what they call it.
I'm sorry?
That's what Allied calls its policy of not allowing people with criminal convictions to work for them. It's called the certified labor program. It's not actually certified by anybody.
Thank you,
Thank
counsel.
you.